start. So good morning and welcome to you wherever you're joining us from today. It's great to have you with us. I'm Paul Tomkins. Now, having seen the attendance list and looking at the list of participants down the right-hand side of my screen, it's great to have some people on the webinar I've worked with before or who know me already. But for those of you who don't, I've worked for Freeds for almost 20 years. I know I don't look old enough for that. And I now head up our property litigation team, which is made up of some 25 lawyers across our offices. So it's my absolute pleasure to welcome you to the first in Freed's coronavirus webinar series. Today is property question time, which is an opportunity for me to respond to some questions I've been frequently asked over the past few weeks, as well as those submitted in advance by you. So thank you so much for all the questions we've had. Unfortunately, I'm not going to have the chance to get through them all today due to the limited time we have together. But if I don't get the chance to address your question today, I will come back to you individually after the session. I should also say, welcome to my home. So it's usually much more noisy than this. Mrs. Tomkins has very kindly taken our 3 children out for their allotted daily hour of exercise. In fact, decibel levels have been particularly high this morning because our youngest turns 5 tomorrow. So I'd better get on with this because they'll be back in an hour and then you won't be able to hear me at all. So what's the format for today? Well, I'm going to run through questions I've received and share my thoughts on them. The topic I'll spend most time on will be landlord and tenants options around the payment of rent, before moving on to consider compliance with break options during this period, and also looking at a question I've had concerning execution of deeds. I'll then move on and look at some other questions. Couple of housekeeping points. So you're all on mute. So if you've got any issues with the Zoom call at all, please use the chat function and contact the host, who some of you will have seen at the start of this call, Rebecca, who hopefully will be able to help you. If you want to log a question whilst we're ongoing, then there is at the bottom of the screen a Q&A button. So if you press that, your question will come through, will pop up, and I'll check in with that at various points during this morning's session. Also, for any of you who've been to any of my sessions before, you'll know I like a good bit of interaction. So with that in mind, we have got some polls to keep you on your toes this morning. And so we're going to launch the first poll now, or Rebecca's going to launch the first poll for me now, just to make sure the technology is working. So if you can vote into this, so what I'm going to ask you to do is to say which of the following categories would you say you primarily fall into? So are you a landlord, a tenant, a lender, another property professional, I'd include lawyers in that, or would you say you're just so bored due to the lockdown that you'll watch any old webinar? So we'll make that active now, and we'll give you about 20 seconds to vote. I'm hoping not too many of you are going to click the last one, but you know, we'll see. I'll take anyone watching. So I can't actually see the, oh, here are the results. Excellent. Okay. 1% of you so bored due to the lockdown you watch any old webinar. Well, I'm going to have to find out who that is, clearly. But great to see the sort of split of the people on the call. No lenders, so that means I can say anything I want about lenders, I suppose. I'll probably be careful anyway. Thanks to someone for the first question asking about my smart haircut as well. So it's good to see we've got some light questions coming in, as well as hopefully some slightly more challenging ones as we go. So what I'm going to do with you now is I'll share my screen and I'll run through a PowerPoint presentation that I've prepared in advance of the session this morning. So here we go. So welcome to property question time, as I've said. So I'll just run through this, and without further ado, we'll get on to the first question I've had, which is around rents. And I've had a lot of questions around these. So I've tried to choose one from a landlord perspective and one from a tenant perspective. So first question is this: a number of our tenants have paid no rents due on the 25th of March. And if the lockdown continues beyond the 24th of June, we may not receive rents due then. We do not want to pursue aggressive action against tenants, but please advise on what steps we may take. Slightly just flipping it on its head from a tenant perspective, We are a tenant of multiple commercial sites. We've paid some of our rents, but not all of them. Given government restrictions, what action can landlords realistically take before the end of June? So here's a list, really, the menu of landlords' options, which I will run through. The landlords generally are going to be looking at all of these different enforcement options at the moment. You've got your good old court proceedings, you've got statutory demands or an insolvency process, commercial rent arrears recovery or CRA, forfeiture, rent deposits, and pursuing guarantors. So let's move on and look at each of these in turn. So what I've tried to do for each of these remedies is produce a short table which sets out ultimately what the remedy is, a brief overview of it, the advantages, the disadvantages, and whether there are any COVID-19 government restrictions. And actually at the end of this session, I've got a nice one-page A3 handout, which we'll send to you all, which has all of these tables on. So don't worry too much about trying to take notes if you're thinking about doing that now. So court proceedings. So what's the overview? Well, a landlord can obviously issue a claim against its tenant to recover rent or other sums due under the lease. Now, the big advantage with this is that in theory, from a landlord's perspective, a tenant shouldn't have a defence to the claim. A landlord should also be able to claim interest due under the lease and claim its costs. Another benefit, I think, potentially, is that having spoken with a number of tenants, they're seeing this as not a particularly aggressive action. Don't get me wrong. They do not want landlords to sue them, but what they are saying is it is giving them a bit more time to pay and ultimately try and agree a way forward with their landlord. Now, in terms of disadvantages, it can be expensive and it can be protracted. What we're seeing with court proceedings at the moment is a bit of a logjam. So people are putting claims into courts, but ultimately the courts are only dealing with the most pressing and urgent matters. So what we will likely to see as and when lockdown is lifted, is that there is likely to be a big queue of claims that are going to have to work their way through the system. And I know from my own experience, when I'm sending claims to court for issue, they're obviously taking a number of weeks to come back. So there's already that delay in the process. Now, there are no restrictions at present on this. But the other disadvantage, I would say, now bear with me here, I often think court proceedings and judgments, they often remind me of this chap, Neville Chamberlain. Where the heck are you going with this, Paul, you might think? Well, in 1938, Neville Chamberlain comes back from Munich waving that piece of paper in the air, declaring that we have peace in our time. But much like that piece of paper, which proved to be fruitless, we were at war within a year, a judgment is just a piece of paper. It doesn't guarantee payments. You then have to go off and you have to enforce and you have to get payments. So the judgment is really only as good as the liquidity of the person you're pursuing. There you go, bit of history as well as a bit of property for you. Moving on to the next remedy. So this is probably the one which within certainly the last week has been the most talked about. And this is a landlord's right to serve a statutory demand or winding up petition or bankruptcy petition in the case of an individual where a tenant hasn't paid the rent. And simply, if you've got an undisputed sum, a landlord can serve a statutory demands, and if it's not paid in 21 days, they can start a winding up process. And if it's for a company, only £750 needs to be outstanding. Now, in traditional times, the threat of insolvency proceedings is often enough to prompt a tenant to pay, because once you have a winding up petition that's issued and presented, then that is then advertised, and often that can be game over for a tenant, as lenders will stop to commit cash to that business. Now, in terms of disadvantages, obviously you are forcing an otherwise solvent tenant or company to the wall, and they may have been able to make payment if they've been given more time. And I think there is also a PR perspective to this that you need to keep in mind. Actually, should a landlord be pushing tenants to the wall at this time? Now, what we were seeing before last week, and certainly what I was seeing, was a lot of landlords were going down this route. There have been rumblings it was going to be prevented, but there was nothing coming through until last Thursday when we had a press release from the government. And the press release from the government said that there was going to be legislation brought forward in this corporate insolvency and governance bill that was effectively going to ban any statutory demands served between the 1st of March and the 30th of June, in relation to rent, which I'll come on to in a second. And it was also going to avoid any winding up petitions issued between certain dates, starting on the 27th of April. Now, we've been waiting all week. I have to say, I've been desperate for the legislation to come out in advance of this webinar, but it hasn't. And I do wonder, when you go back to looking at the actual press release that was issued by the government, as to whether they may be struggling with the drafting of this. And I've just highlighted a couple of points in the government press release here on this slide that you'll see on the right-hand side of this at the top. Tenants are still being asked to pay what they can during the pandemic. Now, how you draft for that, I don't know, but that's what the government is saying. On the second arrow, you'll see that the temporary ban of statutory demands and winding up petitions is to apply to where a company cannot pay its bills due to coronavirus. Now, in my mind, that differentiates between a company that cannot pay due to coronavirus and does not want to pay due to coronavirus. And I think what you are going to see, as and when this comes onto the statute books, is landlords asking for evidence, financial evidence, as to why a tenant isn't paying its rent. Is it that it can't pay it, or is it that it doesn't want to pay it? So if you're a tenant, I would say prepare yourself for that type of question. Now, moving on to commercial rent arrears recovery, I'm often reminded, I'm sorry, you're going to get a real insight into me here, but I'm often reminded of one of my children's favourite jokes about pirates when it comes to this, CRAR. So what's a pirate's favourite enforcement remedy? It's CRAR. Anyway, let's push that to one side and let me get back to the meat of the topic. So commercial rent arrears recovery is in effect the law that replaced distress. It's bailiffs going to a tenant's property to take control of goods and sell them to recover the value of the debt. Now there is a notice procedure that a landlord has to follow, giving at least 7 days notice before it exercises this right. And it's usually very effective. Once you've got bailiffs on the premises, it's amazing. Payments. In terms of disadvantages of payments, it's only considered rent, that's always the case, not service charge or insurance rates. And it's going to be an issue. You can't go into premises and seize goods if they're closed. And similarly, if you do manage to seize goods, you can only sell them at public auction, which again, of course, is a real problem in the current crisis. Now, the government has also restricted this remedy by saying that rather than there just being at least 7 days arrears due, you now need 90 days. So effectively a quarter's rent must be unpaid before you can exercise CRAR. And so any well-advised tenant here, I think, is going to make sure that if they are owing rent, that it's just going to be for 1 quarter. So if you owe over 1 quarter and you're worried about CRAR, make sure you bring the arrears down to a quarter or less. Now, one of the other remedies that caused most discussion a few weeks ago, this seems like years ago to me, given everything that's happened, is forfeiture. And forfeiture, of course, is that landlord's right to re-enter premises either by peaceably or by going down a court route and ending the lease due to a breach by the tenant. And the advantage to a landlord often is that it can re-let the premises on more favourable terms, although that's probably not the case at the moment, or perhaps develop them or use them themselves. But of course, the problem at the moment is that it's not going to be in most landlords' commercial interest to take the property back. You can have complicated applications made for relief from forfeiture by tenants or subtenants. You've always got the risk of waiving the right to forfeit inadvertently, although there's been some clarity on that, which I'll speak about in a moment. And also, of course, once the landlord takes the property back, they become liable for costs such as void rates, etc. And let's say there's another 3 years to run on the lease, well, they can't claim the rent for that next 3-year period. But of course, what the Coronavirus Act did, and more specifically Section 82 of that Act, is it placed a moratorium, put in place a moratorium which prevents landlords from exercising the right of forfeiture due to non-payment of rent up until the 30th of June. And it also says that they cannot waive their right to forfeit in respect of a failure to pay rent during that period, unless they expressly do so in writing. But of course, come the 1st of July, unless this is extended, the gloves are off in theory, and landlords can use this remedy again, but for now, it's on pause. A couple of other remedies, which are not necessarily direct remedies against tenants, which is going to force them to take immediate action. Rent deposits. So a well-advised landlord at the moment should be considering what rent deposits they have available to them that they can draw down against. It's a very quick and simple way to recover rent, and often some other money is due under a lease, and it should preserve the landlord and tenant relationship because there's no impact on the tenant's cash reserves. Now, you do need to very carefully consider a rent deposit deed when you're doing this, because there will be specific notice provisions that you will have to follow before you can withdraw the money. If you don't follow those notice provisions, you will have wrongfully drawn down and you could be in trouble. You also need to consider if there is a risk of tenant insolvency, then there can be a dispute as to whose money it is. Is it the tenant's money that the landlord holds on trust, or is it the landlord's money that it can use? And there can be a dispute as to who actually owns that money, but that should be dealt with within a well-drafted rent deposit. Also, most rent deposit deeds will oblige a tenant to top up the deposit once they've had the monies drawn down. But of course, at the moment, they may not be able to do that. That may not be a concern to landlords once they've got the cash in the bank. And the benefit with rent deposits is there are no COVID-19 government restrictions. Now, what about guarantors? So in terms of guarantors, you've got two different options. You've got a current guarantor, and then you've got the option of pursuing a former tenant or their guarantor. So if you're pursuing a current guarantor, then ultimately you can take whatever action you want against them. You could issue court proceedings. In theory, you could serve a statutory demand on them, because at the moment the government restrictions only appear to relate to tenants. So we'll have to see whether that remains the case once we get clarity from the legislation. But there are obviously risks in that the guarantor may no longer be solvent, or you could push them to the wall and ultimately not get the money when you get ranked in the list of creditors. Now, I flag up the position with former tenants or guarantors here, because I think one thing that people should be aware of as landlords and or as former tenants is that if you're going to pursue someone using an authorised guarantee agreement, then you will need to serve a notice under Section 17 of the Landlord and Tenant Covenants Act within 6 months of the sum falling due. And if that notice isn't served, then you will lose the right to pursue that guarantor. And this is something that I fear that with some parties may be slipping through the cracks, because actually what landlords are doing is, of course, trying to document arrangements with their tenants. But of course, what if the tenant defaults on that arrangement in 9 months' time? You may have lost the right to claim that money from your guarantor. So my advice to my landlord clients is carefully consider serving these Section 17 notices either now or after the June quarter day, so that if you do need to revert to them and do need to pursue them, then you can. Okay, so that's a very quick run through all of the remedies. So I need you to do a bit of work now. So I'm going to give you this scenario, and imagine you're a landlord. So here we go. So a lease of this lovely looking high-end restaurant premises. The rent is payable quarterly in advance on the usual quarter days. And the restaurant's been shut since the 23rd of March, and the majority of staff have been furloughed. They're producing a takeaway service. And on the 25th of March, the tenant paid the rent for a month, basically, up to the end of April. And they asked the landlord to agree a payment plan for the remainder of the quarter. And what they've proposed is paying the balance of the March quarter in 6 equal instalments, starting 30 days after the lockdown is lifted, with no guarantee or a rent deposit. So here are your options. So as a landlord, what do? Do you agree to the tenant's proposals to basically defer the payments over a 6-month period after lockdown? Do you issue court proceedings? Do you pursue one of the other enforcement remedies I've talked about? Do you try to agree alternative proposals with the tenant? Or do you simply decide to wait until after the 30th of June, when a number of the government restrictions are lifted, and see what remedies you can pursue then? So we're going to have a poll on this, which should go live, and you've got some time there to cast your vote. Okay, we should be closing the poll in just a moment. Let's see what you went for. Okay, so that's very, very interesting and potentially not the best news for a property litigator at the moment, because none of you have said we would issue court proceedings or pursue some other enforcement remedy. What the vast majority have said, 36% said, yeah, we'll take the rent over a 6-month period, that's no problem. Almost half, you say we'll seek to agree proposals with the tenants, okay? And 14%, we're going to sit tight and we're going to see what happens. Okay, that's interesting. Let's just change the facts ever so slightly. So these are exactly the same facts, but the one key difference here is that you have a rent deposit, which is equivalent to 6 months rent, and you have a guarantee from a PLC company. That's the final bullet point. So what do you do in that scenario? So running through the options, you can still agree to the tenant's proposal, you can issue court proceedings or pursue some other enforcement remedy. You can draw down monies from the rent deposit or claim from the guarantor. You can seek to agree alternative proposals with the tenant, or again, you can sit tight and wait until after the 30th of June. So what do you do? Let's see if any of you are going to actually get a property litigator working on this one. Let's see. Oh, good, excellent. Yes, 58% draw down from the rent deposit or claim from the guarantor. And I think that is exactly what I would be advising a landlord client to do at this time. If you've got a third party or you've got a rent deposit to propose to go with, then that is the route that I think I would be advising my client to take in that scenario. It's interesting that we've had 2 people who've now said they would issue court proceedings or pursue some other enforcement remedy. So on that one, so I'd be interested to perhaps catch up with you later as to what exactly you think you would do in that scenario, but that's interesting. So let's now flip this. Let's say you are a tenant. You're a tenant of this lovely gym with these boxing bags here. Punch bags they're called, aren't they? That shows how often I go boxing. So you've got the rent payable quarterly in advance on usual quarter dates, and the gym has been shut again since the 23rd of March. Majority of staff furloughed, no rent at all paid for the March quarter. But with Sunday on the horizon, we have over the next few weeks, restrictions are lifted. So the gym can reopen, albeit numbers of members attending are limited and other safety precautions have to be taken. And the tenant doesn't have the funds to pay on the 24th of June. So it's now the 1st of July, no more COVID-19 restrictions. As the tenant, I ask you, what are you most concerned about the landlord doing? So are you most concerned about the landlord issuing court proceedings? Are you concerned about an insolvency process? Is it CRA? Is it forfeiture? Or are you not concerned because actually as a tenant, you are confident that the government will enact further restrictions to protect you? So here you go, let's make that poll live. So let's see what you've said here. Insolvency. I mean, quite an even spread between insolvency, CRA, and forfeiture. I think a gym owner would be certainly concerned about CRA. They'd be concerned about the landlord being able to take away equipment. I think forfeiture, of course, you're going to lose your opportunity to trade from that premises. But I think insolvency, I think you're absolutely right. I think that insolvency is the thing that most tenants are going to be concerned about come the 30th of June. And I think also that last one, I'm confident the government will enact further restrictions. I think, for my personal opinion, I think come the end of June, I'm not sure that the government is just simply going to say the gloves are off, you're allowed to do whatever you want at this stage. Landlords, do your worst. So I think it wouldn't surprise me if there is a further delay on insolvency processes, but we will have to sit and wait. I certainly don't have any inside information on that, but we'll have to sit and wait and see what happens from the government. So just before I move on, I have had a couple of live questions come through. One of them is from an anonymous attendee who asked me, does this mean the secure REIT stat demand will likely be allowed? I think it depends who you're serving statutory demand on. So if you're serving a statutory demand on a company other than Tenant, then certainly at the moment, I don't think there's going to be a restriction on that, but we'll have to wait and see. And with a question from Siobhan Priest, thank you, Siobhan. For a drawdown of deposit or claiming against the guarantor, this seems costly, especially with a large and varied portfolio of tenants and leases that will need individual review. That may well be right. You might be correct on that, Siobhan, but also I think what you have to weigh up against that is that actually there is an opportunity to get that cash within your account. And so I suppose there's a balancing exercise to work out there as to which rent deposits you hold and you can easily access. And hopefully your advisors will be able to assist you with that. So moving on, just a couple of more general questions I've had. First one is, we're receiving requests from tenants for rent payment holidays. Please provide your advice as to whether we should be agreeing to these. And then the second one, which came in this morning actually, but I just quickly popped on the slide because I thought it was a good question. Are any patterns beginning to emerge on what are realistic deals that are acceptable for both sides for rent waivers or suspensions, or is it still on a situation basis and a sector by sector basis? Now, I'm afraid I think there is very much not a one size fits all approach here. And what landlords are doing is looking at each case individually. And I think that's what you have to do. I think you have to weigh up the liquidity of the tenant, you have to weigh up your own position with the lenders, and other factors which are going to be relevant for you, such as, is the tenant still trading? Are they actually able to earn any income during this period? So I'm afraid you do have to take it individually. And I think what I've perhaps been surprised by, and the question I've been asked the most over this period, is what are landlords generally doing? And actually my experience is telling me that landlords are taking very individual approaches. I don't think there is a one size fits all. Most appear to be amenable to some sort of arrangement, but not all. Next question. Is it dangerous for clients to document temporary compromise deals themselves? Well, it's not going to be surprising to hear me as a lawyer say, yes, I think it is. I think there are potentially wide-ranging ramifications of these side agreements, and actually you do need to be very careful about putting them in place. And so my suggestion would be to you that you do take advice on that prior to putting any intake in place. And actually just on that, we've just had a question come through from Luke Plymouth. Thank you, Luke. Are there any hints and tips for documenting payment plans and pitfalls to avoid? Well, most people have gone down a side letter route, which seems sensible to me, but there are certain things that you do need to consider with that. For example, do you want the arrangement to bind a successor in title? So let's say, for example, you're going to potentially assign a lease or have an assignment of a lease. Actually, do you want the benefit to pass on to someone else? As a landlord, if you're trying to sell your interest, you want it to pass on to someone else, you should deal with that expressly in the side letter. There was also a case, I'm not sure if it was last year or the year before, involving Vivian Westwood. I was going to say Vivian Westwood then, but it's Vivian Westwood. And Vivian Westwood was all about whether provisions in a side letter, which basically said the rent payment arrangement automatically ended if a tenant failed to make a payment, was a penalty that was unenforceable. So the level of rent went back up automatically if a tenant failed to make a payment. And in that Vivian Westwood case, it was held to be a penalty and it was held to be unenforceable. So there are certain issues you do need to be thinking about in the drafting of side letters if that's something a route you're going to go down. Okay, so let's move on to breaks. This is perhaps the topic next to rent that I've received most questions on over the past weeks. So a couple of questions on this I've put in. First one, if the tenant does not pay the rent due to COVID-19, would this invalidate a future break? And the second one is, please let us have your views on compliance with the vacant possession requirements of a break clause during a period of lockdown. So thank you to the people who submitted those questions. So let's go back to basics here, okay? So with a break, there are no prizes for coming close. You either strictly comply and the lease ends, or you fail to comply and the lease doesn't. And someone that always comes to mind with me with this is Paula Radcliffe. So Paula Radcliffe, the image that comes to mind for me with her is this, her often finishing 4th or 5th in an Olympics or a World Championships and coming close but no cigar. You may have a different image of her squatting by the side of the road during a marathon, but that's your issue, that's not mine. My issue is definitely this one. If you like a different sport, what about penalty shootouts? Well, you either win or you lose. You don't come anywhere close, and this is one of my favourite penalties in that regard. Just to give a bit of a laugh, I'll share that a couple of times. Ow, that definitely hurt. Anyway, so here's a break clause. Let's imagine this is the break clause we're working through here. So the tenant may end this lease on the 23rd of May 2020 by giving to the landlord not less than 6 months' notice in writing of its intention to do so, following which the lease will end on the 23rd of May 2020, subject to the tenant complying with the following conditions. So number 1, it must pay the annual rent falling due under the lease on or before the break date. And number 2, it must yield up the premises to the landlord with vacant possession on or before the break date. So what about the rent provision? Well, it's just best to go back to this case. This case, I think, illustrates the position with rent very clearly, and it's from 2012, PC Investors and Cancer Research. You've got a rent payment cycle, which is on the usual quarter days, and PCE is the tenant. It serves a break notice to end the lease on the 10th of October 2010, and on the 29th of September, rather than paying the full quarter's rent, it tenders a payment just up to the break date, the 11th of October. And what the court has to consider is this good enough? Does this comply with an obligation to pay the rent that's fallen due on or before the break date? And the court says, no, it doesn't. And the position with COVID-19 is that there are no changes to this rule, as far as I can see, none whatsoever. The simple position is that if tenants have decided not to pay their rent during this quarter, or have paid some but not all of their rent, and they have a break that falls due during this quarterly period, which is conditional on them paying the rent in full, they will have to pay the rent in full. COVID-19 will not save them. So if you are a tenant with a break during this time where you've not paid the rent and your break is conditional on you doing so, I would strongly advise you pay the rent. Now, what about vacant possession? So again, back to the law on this. What is the law? So we come back to John Land Construction and Amber Pass, which sets out this two-stage test as to whether a tenant has given vacant possession. And the first test is the tenant still using the property? And the second one is there a substantial impediment to the landlord occupying or letting the property? And if the answer to both of those questions is no, then the tenant has complied with the vacant possession requirements. But if the answer to one of those questions is yes, then the tenant has not complied with the vacant possession requirement. So this is a case which a number of you may recognise from just a few years ago, Riverside Park and NHS Property Services. I won't run through all the details because these slides will be sent out to you, but in this case, there was some partitioning that was left on the property by the tenants, and there was a question about whether it was their partitioning or the landlord's, but by the by, it was held to be the tenant's partitioning, and ultimately the court came to the view that meant there was a substantial impediment to the landlord's right to occupy, meaning the tenant had not complied with a vacant possession requirement. Now, it's not always as cut and dried as this. Have a look at this. So a few years back, I was advising a landlord, and the day after a break date, it went into the property and it had a look around, and the tenant had cleared the majority of stuff, but had left a few boxes, including some kind of skeleton you may see in that post to the right. So my question for you is, do you think, looking at these photographs, the tenant had given vacant possession on the break date? So let's issue that next poll for that. Okay, 50-50, guys. So we'll close that poll. Let's see what people thought. Oh, strong for no, 77%. Okay, well, we didn't go to court on this, but what I can tell you is that the tenant paid the landlord pretty much a year's worth of rent to get off the lease very quickly. So I think the tenant certainly thought it had a problem. And it was that age-old issue where it had contractors who didn't quite realise the importance of getting out by the relevant date. Now, there are some relevant COVID-19 restrictions, I think, here as to giving up vacant possession. And they're not, it's not property legislation. It's within the Health Protection Coronavirus Restrictions England Regulations 2020. Snappy, I know. Most people call them the lockdown regulations. And within those, you've got Regulation 5. And Regulation 5 says that retail premises that are not specifically exempt from the closure order must cease to carry out business, save for providing deliveries. And it also says business owners must cease admitting any person to their premises who are not required to carry on its service as permitted. Now, to my mind, that means that if you were a tenant and you were looking to get in a contractor to strip out a premises, you would be in breach of Regulation 5 if you did that. Now, what's the effect of that? Well, Regulation 9 says that if you commit an offence, so if you breach that regulation without reasonable excuse, a reasonable excuse of those sorts of things we're allowed to do, go out and exercise, go and buy medical supplies and food, those types of things, then the offence is punishable on summary conviction, by a fine. But what if you're a tenant company? Well, the offence is not just for the company. It potentially is also for the director, the manager, or the secretary who makes the decision. And there's even some wording that says even if it's negligently made, you can still be caught. And what the actual regulation says is that you are liable to be prosecuted and proceeded against and punished accordingly. So it's a criminal offence, this. So tenants, in my view, are somewhere between a bit of a rock and a hard place. You may have to, from a lease perspective, comply with an obligation to clear out your premises. But if you look at these regulations, you may be committing a criminal offence if you do so. So I think what is likely to happen, I mean, don't get me wrong, these lockdown restrictions may well be changed in the coming days, such that it makes it easier. But what I foresee coming down the line are arguments between landlords and tenants as to what constituted vacant possession within this period. Was it good enough? Would actually leaving a few boxes on, like on those pass photos, be good enough in a period of lockdown, as opposed to in a normal period? And we're going to have to see what comes down the line with that. Now, before I move on from breaks, I have had just a couple of questions on that. One of them from Eddie Cook. Good morning, Eddie, and thank you to you. You've said if a notice is served by post but not email, but the landlord's offices are closed due to COVID-19, does this mean the break notice is invalidated? Well, I'm going to give you that classic lawyer's answer and say it depends on the lease. The vast majority of leases will say how you serve a break notice. And actually, on the ones I've been looking at during this period, most do permit service by first class post. And there is a deeming provision to say that if you put it in the first class post, it's deemed served a number of days later. So actually, what I've stopped doing, what I did as a matter of course, was tended to serve notices by some form of registered post or recorded delivery. I'm not doing that at the moment, unless I absolutely have to, because in the vast majority of cases, as you say, there is no one there to sign for the letter, and that means it's just returned. So it's something to watch out for. In terms of a question from Roger Davis, thanks Roger. What happens if a future break beyond COVID-19 if there are historic arrears? So what I guess you're saying is, let's say the break is in September and the tenant hasn't paid March but pays June. In theory with this, if the break is conditional on all rent being paid, any historic arrears will also invalidate the break clause. I'll come. There's a question there about administration, which I'll come back. I think great question from Sam Rickett. Morning, Sam. Carry on services permitted. Would this include in a retailer who is exempt, for example, DIY stores and food retailers? Would a fit out contractor not be considered to be carrying out services permitted? I think you've got a good argument for saying that. I think what I was really focusing on the regulations here is where you're not a provider who actually can continue to provide a service. I think it's going to be, you'd have to look very carefully at the regulations if you are a food retailer or a DIY store, or bike shops, for example, that are on that list, to see actually, look, can we, pursuant to these regulations, get people in to carry out these strip out works? So thanks for all those questions. And just to say, Patricia Began, I have seen your question, and I will come back to you on that. Although I've just had a follow-up question. So you said, re your answer to Roger's question, what if you agree a payment plan as side letter rather than variation? Would tenants still be up to date with rent and can exercise the break? In my view, if you have not documented it as a variation, you are at risk as a tenant in that situation if you don't pay all of the rent. I think if you are going to have that and you've got a break date coming up, my advice to you would be to do a variation to the lease to make it clear rather than rely on a side letter. Okay, moving on. Next question. Can I sign deeds electronically during the COVID-19 crisis? So we're in a strange old world here where most people will accept digital signatures on documents. We had a case last year called Neo Clearson Rees, where you had an exchange of emails where the exchange of emails was considered to be good enough to have a signed agreement. So we are in a world where this is acceptable, and the Law Commission doesn't seem to have any issue with digital signatures. The issue that we do have is the land registry. So the land registry will not accept a deed for registration that has not had a wet signature on it. They don't quite insist on a quill, but it's almost the case. So even in the current crisis, if you have a deed that has to be registered at the land registry, you will still need to wet ink signature it. There are some, you can still now sign a scanned copy into the land registry, which they will accept, but ultimately you are still going to have to sign it off in wet ink. In terms of getting it witnessed, our view is that provided it's someone in your house, and someone in your house can witness it, provided they are not a party to the transaction. So that does make life slightly easier getting something signed in a COVID-19 world. So just moving on to a couple of other questions I had in advance of the session, which are just more general. The first one is there any proposal to automatically extend rent-free periods and lease terms where tenants have been unable to use or fit out their premises? And I'm afraid the answer on that is no. It's really up to negotiation, and personally I cannot see the government getting involved with this. I think it's going to have to be agreed on a case-by-case basis between parties. But if you're, for example, your agreement for lease doesn't govern an extension of a rent-free period where you can't fit out due to exceptional circumstances, it is something that would have to be agreed directly with your landlord. This question I loved. Great question. As the government has said, we are not permitted to open. If a government department is the landlord, do you have to pay rent? Well, I'm sorry to say to Nigel Jones, who submitted this question, that the position is that the government in this case has no other restrictions on it as a landlord other than any other landlord. My guess is that they are not going to be particularly keen on pursuing a tenant for not paying the rent, particularly if you comply with the press releases that have been issued. So the press releases that say pay what you can and talk to your landlord, and be proactive. My advice would be make sure you throw those words back in your landlord's face and ensure that you are trying to agree terms with them as to how you deal with the situation. And this is obviously more future gazing here. What additional clauses should be included in future leases, and can any be retrofitted? And do you have any suggestions for clauses in new leases which would cover future COVID-19 scenarios? Well, I think the thing that perhaps most of us have realised at the moment, and the potential gap in current leases, is that we obviously have insured risks wording that says that rent will be suspended when the premises are damaged such that they can't be used by a tenant. And the reason for that is that landlords can get insurance which covers them against that risk. Now, a lot of people have been saying, should those insurance provisions also cover a situation where you are not permitted to occupy due to government restrictions? And I think that is going to be an area that tenants are going to be very keenly looking at in the future. The challenge, I think, for landlords on that is that going to be insurable? And my guess is that it's probably not. I think insurers are going to be very wary about agreeing those policies, or if they do, there's going to be a considerable cost to them. And the question is whether tenants who are effectively going to have to pay for that insurance through their insurance rents are willing to do that, willing to pay that enhanced cost to cover off this risk. So that's something that we'll have to wait and see. I think that what we're also going to see potentially is more of a drive for a turnover rent culture. We might see something along the lines of, I'll only pay you equivalent to what I actually get in, which I think is probably, I can understand certainly why tenants want to do that in the circumstances. And I think we're generally going to see more flexibility. I think tenants are going to be looking for shorter leases. I think they're possibly going to be looking for options to exit during similar periods such as this. But of course, as with any sort of discussion on terms, it is really going to come down to what the party's bargaining position is. So that's all my slides there. But I can see I've had a few more questions come through. So just to go back to this question on tenant administration from Patricia Began. Thank you, Patricia, for your question. You said, if a tenant is in administration, what constitutes occupation? And are they liable to pay rent even though the unit is closed? Well, the general rule with administrations is that administrators are required to pay rent whilst they use or occupy the premises for the purposes of the administration. So the question is, are they using the premises for the purposes of the administration? Now, I can see an argument on this both ways, but ultimately my view would be, if an administrator is not saying to you, we don't want these premises anymore, then in my view, rent would be payable as an expense of the administration, and it would probably be payable on it will be payable on a daily basis. Clearly depends on the particular circumstances, but that's my view on it. Just another question on signing. Absolutely right. There's a comment made here that Land Registry have put in new practice this week that are temporarily accepting something called Mercury Signing, which is effectively, so if you need your client to sign a document, all they have to do is print off the signature page, sign the signature page, and send it back to you with the complete document, such that we don't have to send out as lawyers a complete big chunky agreement, or someone at the other end doesn't have to print out that chunky agreement. It still doesn't get past the fact that you still need a wet ink signature to apply. You need a wet ink signature for deeds, and also you may need a witness. And for some companies, you might need it signed by 2 directors, such that you will have to get one sign in one place and then sign it to the other person to sign it in another place. So that's still something else to look at. One more question that's come through from one of my colleagues, from John Flathers. Good morning to you, John. You've said, do you have any thoughts on whether the law of frustration will be applied to leases? It has been resisted for years by the courts in relation to lease termination. Well, again, this is a topic which has prompted a lot of discussion. And actually what I would say to you is, if you have a particular interest in this topic, have a look at the Wilberforce Chambers website. There's an excellent little chat between Joanne Wicks QC and Jonathan Seatler QC on this very topic, which is really good. But the nub of this is that courts have been incredibly reluctant to allow tenants to terminate leases as a result of frustration. You'll remember there was a case to do with a building in Canary Wharf recently, European Medical Agency, which all argued the point that that lease was frustrated as a result of Brexit, and ultimately that didn't work for the tenant. But there is also a case which I think you can look at, which you might say at this, when we have an uncertain period as to how long tenants are not going to be able to use premises for. There's a good case which deals with an Austrian inhabitant of a seaside town during wartime, and there was a government decree at that time that foreign aliens, and him being from Austria, he was a foreign alien, weren't allowed to live in seaside towns. And he had a lease, and he tried to claim that that lease was frustrated as a result of that government decree. And the government said, the court said, no, it wasn't, because he had an ability to assign the lease such that it could continue. So it wasn't frustrated in that scenario. The general sort of thoughts on this is that if you are a tenant and you have a relatively limited period left on your lease, and there is no prospect of you being able to assign it. So let's say you operate, I think on the web chat, Wilberforce Chambers talk about it being a high-end restaurant. So there's no other restaurant chain that's going to come in and take those premises. Well, you might have a better chance of arguing that the lease is being frustrated, but it is still anywhere, it's not certain at all. And one of the other tips they give out on that, one of the other tips that went out on that webinar was actually perhaps potentially looking at some cases in the US around prohibition. So when prohibition was brought in, a number of bars claimed that their leases have been frustrated, and that's an argument that may well be run by other people. So watch this space. I think we may well see some case law on it, but given that we are anticipating seeing government restrictions perhaps lifted in the next week, let's see what exactly happens on Sunday, it may be that this argument about frustration falls away. So that completes this morning's webinar. Those are all the questions that have come through. So I hope I've dealt with your questions. If you didn't actually put a question in, but you'd like to pose one, please feel free to do so. Just log one. What we're going to do this afternoon is we're going to send out an email to you with the summary of the remedies that I talked about earlier. A nice one page. You can pin it up on your wall if you want to at home, and you can refer to that as and when needed. There'll also be some feedback forms on there. We love your feedback. Obviously, this is the first webinar we're doing in this series, so it'd be great to know how you found it, and how the format you think has worked for you. If you have any questions in the meantime, please feel free to get in touch with me directly. I'm really happy to speak with you about any questions you've got, and my contact details will be on that email. And as I said earlier, we will follow up on any questions that you have asked that haven't been addressed on the webinar. Sorry, we'll follow up with you individually. But for now, that's it from me. I hope you all have a great bank holiday weekend. Enjoy the sunshine, and I hope to see you again soon. Thanks a lot.